Okay, so the rules in force at the time of commencement of arbitration. Who gets to decide the time of commencement of arbitration?
But who? Is it the parties to choose the commencement, or is it SAYAC? Is it the tribunal?
She said the registrar. Okay, is that decision binding in any way? And by binding, I mean binding to the parties, to the institute, and can the parties agree otherwise? Does anyone else think otherwise? That it's binding and you cannot derogate from it. You cannot choose otherwise.
So if I may, Ghada, so let's differentiate between the version of the rules and the commencement date. So if we read the articles related to those two topics, are they the same when it comes to agreement otherwise or agreeing otherwise, or they are different? So when it comes to the version, I think it says, as our colleague just said, that it should be starting from 1st of January 2025. It is the 2025 rules unless otherwise agreed. What about the commencement date? If we open SAYAC, the article or the rule for the commencement, does that give the parties the right to derogate from the selected date of commencement? Let's open SAYAC.
Hello, everyone. Are we audible to you? Sorry, we are on the online call.
Someone in online.
Yes.
Yeah.
Hi, Ghada. It's Bo Khodar from University of World Economy and Diplomacy. It's really nice to see you. Are we audible?
Aziza, you can unmute.
Sorry, are we
Hello.
audible? Yeah, great.
Yeah, are we audible? We are from the University of World Economy and Diplomacy team. I guess we're not really audible.
Yeah, I think they're trying to figure out somehow to get this thing done.
Anyone?
So basically what Noef is asking are Article 1 of SAYAC Rules 2025 and Article 1 of SAYAC Rules 2016, do they differ in any way? Or it's the same mechanism?
What do you think, Ghada?
At least with regards to the rule in force, I believe they are the same. But my concern is, are the decision of the registrar final, binding? And as to the commencement itself, is the rule with regards to the fact that they commence with sending the notice of arbitration, is it a mandatory provision or the parties could agree otherwise to that?
So does that mean that the parties cannot agree otherwise? Okay, but now the SIAC already chose the 2016 rules, right? But it's up to the tribunal to decide. Am I correct? So is that also applicable to the commencement date? So they also, SIAC also decided 31st of July, if I'm not mistaken, as the commencement date. Can the tribunal decide otherwise? Can say, no, it's 19th of December, for example.
Thank you. Whether 2016 or 2025, it refers to the same provision. Unless otherwise agreed by the parties, this rule shall apply with that time of commencement. So since the parties agreed to apply the rules at the time of contracting, then why not? The 2016 shall apply.
Okay, so I think generally this question is very important that we should all know when it comes to the procedural aspect, because this is crucial to understand and to know which rules to apply. The commencement date is very important. The version also is very important. So I think this can be one of the main topics that we can talk about tomorrow. And that's why, I mean, Ghada just said that tomorrow is the big day for like discussing the different issues and so on. So we need you to tell us what is important for tomorrow and what's not important. And when you say not important, maybe it is important, but you already know the answer. So we only have limited time, so we need to leave the room with as much answers as we could.
Okay, so we have no SAC rules do not give parties the right to derogate from the rules regarding the commencement of arbitration. Notice of arbitration starts the arbitration proceedings. According to which provision? I mean, when you say that you cannot derogate from something that it's a mandatory provision, you must have a legal basis.
According to Article 1 itself, I think it's the scope of application. It clarifies the date and also how the arbitration will start.
Okay, homework for tomorrow. So both set of rules have certain provisions about how to actually count how the time runs, okay? And there are also certain provisions about whose decision are mandatory or not, and what you can derogate from or not. I haven't heard anyone mentioning any of these provisions. So while the main focus is going to be Article 1, I think a lot of you are referring to Article 1 of both version of the rules in your line of argument. But I would like to invite you to also read the entirety of the rules. There are several indications somewhere else that could be relevant to your discussion.
Another question is, what are the consequences of applying different rules? So for example, now respondent is asking for certain rules and claimant is asking for the other rules. So the question that definitely you will be asked is that if the tribunal will decide otherwise, so you're asking for 2016, what if the tribunal decides 2025? Is it a discretionary power to the tribunal, or is it an obligation? So if it is an obligation, what are the consequences? Is it going to be annulled? Is it going to be unenforceable? Is it both? Is it none of them? So this is a very important question that if you don't mind, I think we might ask if anyone have any answer. So do you think that this is binding or is it discretionary power to the tribunal? Sorry, so it is binding and discretionary power to the tribunal?
Hello?
Yeah.
So it's a discretionary power of the tribunal to order the disclosure or apply SIAC 2016.
So we're not talking about the disclosure.
Yeah, apply rules 2016 or 2025. It's the discretion.
Reference in the record?
From the rules.
Or from the rules?
I'm not sure.
You must, when you say anything, be ready to give either a legal basis or some sort of reference.
So I think, Sally, when we talk about this, the answer we might find it maybe when we open Article 34 of the Ancestral Model Law, which is a verbatim adoption of the seat of arbitration. They will tell us what is considered to be annulled and what is considered to be otherwise. So I believe one of the sub-arguments that we might find is that if there is any violation of the applicable rules, it is annulled. So now the question is, if I am respondent and I'm asking for the 2025 to be applicable, and then eventually the tribunal decides that the 2016 is applied. So is this a violation of parties' agreement? If it is yes, then we might say that pursuant to Article 34, whatever the subsection is, it is annulled, and therefore, if anything is annulled, if any award is annulled, it will be automatically unenforceable. Do you agree, Ghada?
For me personally, there is no one answer to any of the questions we're asking. There is at least three three answers. So the correct answer is a maybe, I would say. But you need to support whatever your position you're taking with some sort of reference, either a scholarly opinion, the rules themselves, a reference to the record. If you cannot support what you're saying, we won't be able to believe what you're saying. It's just words. We have references to 6.2, 2025 rules, and 3.1 of 2016 rules. I believe these refer to the notice of arbitration. Beyond the notice of arbitration, there are other provisions in the SIAC rules that I would like you to find for tomorrow. Okay, now going back to the very common arguments that most of you probably have. What are you confident in as claimant or as respondent? Be like, this is my winning argument. If I would say you have 1 minute to advance one argument with regards to which set of rules apply. What would you say?
I mean, I think most of you are pleading, so it's either today or after tomorrow you will eventually plead. So we just want to know what to focus on for tomorrow. So we want to hear from you all what are the weaknesses of your arguments and what are the strengths, so we can also work on them for tomorrow. So for 1 minute, as Ghada said, anyone that can volunteer, please.
The AMA protocol. Okay, does anyone know how the ARB-Med-ARB protocol works? Usually, under the SIAC, the regular procedure. Yes.
And then parties can agree to stay the proceedings and go to mediation to try to settle some of the points or all of the issues. And if not, and there's a time limit, I guess. And if that doesn't work, so they go back to arbitration. And the arbitral tribunal is stayed during time of mediation.
Okay. So personally, I had the chance to ask this to one of the SIAC deputy directors directly. That is filing for arbitration like a procedural prerequisite for the ARB-Med-ARB thing? Yes, it is. And that particular step was amended in our case. I believe now we don't have ARB-Med-ARB, we have a Med-ARB. Okay. We are within the confines of party autonomy. My question to you is, does the fact that they altered ARB-Med-ARB to Med-ARB, does the spirit of how the ARB-Med-ARB protocol works and the purpose of it still stands? Obviously, the answer is supposed to differ whether you're claimant or respondent, but what is your position on that?
Well, actually, that was my question for, yeah, but I didn't get a clear answer. But from my own perspective, I think that since the amendments were very substantial, so no, it's not an AMA protocol anymore. This is a respondent's position. So.
As a respondent, my question to you now, as a respondent's position, are you holding that it's not an ARB-Med-ARB protocol, or are you holding that it's a multi-tier dispute resolution clause with 2 tiers specifically, and you're acting oblivious to the ARB-Med-ARB discussion?
No, it is a multi-tiered dispute resolution clause, but it's not the AMA clause. I didn't really get the.
You didn't get my question, because if you're gonna say that it's not an ARB it's not an ARB protocol, be like, so your client was aware about the discussion that happened in the within the board of directors about the shifting from ARB to MedArb.
No, they were not aware. How can you prove that they were aware of the negotiations and the discussions?
Can someone prove that they were aware of the negotiations of the discussions? Anyone from the record?
Maybe the board.
Hi again. Are we audible here?
Volunteers?
So I think
I know you're
there's-
better than I know you're better than this. I know you know your facts. So volunteers? Do you have sufficient proof in the record that respondent was actually aware about the discussions within the board of directors in Herbal Cosmetics?
Ahmed?
Okay, they had access to the services. As claimant, do you have something to counter that? I would say that your client is negligent. Okay, before that, what's the standard of knowledge that you're applying here? Is there a particular legal standard that you're applying or relying on? What's the legal standard under the CISG? Which provision of the CISG? Which provision? Article 8. What's the legal standard under Article 8? Knew or could not have been unaware. That's the fact that they had access but decided not to read them falls under could not have been unaware. That's the question. Not necessarily. But Mr. Abbas did not redeem. Continue.
How to say it? It was one email amongst like 100 other emails. So why look up this email in particular?
Okay.
He,
Mm.
but Mr. Albius wasn't there when the contract was signed with Botanical Gardens, or there's no proof that he was a board member when the contract was signed with Botanical Gardens.
Do you have to, can you counter argue that? Okay, so we have two facts. We have that one fact in procedure order number 2 that they said they had access to the email, including the exhibit C7, I believe. And their argument is that exhibit C7, the content of exhibit C7 is not sufficient to say, well, even if they have read this, doesn't mean that they should know about the time of commencement or that shifting from ARB med-ARB. And then she mentioned that, well, Mr. Albius, the main negotiator, also was a board member. So he was part of the discussion of amending the ARB med-ARB to med-ARB. So he's saying that respondents took Botanical Gardens' position and including all of its liabilities and commitment. This includes, I believe, the dispute resolution clause.
But the question is, when you say that I will assume all of the commitments and liabilities, does also the intentions between botanical garden and claimant also will be transferred to respondent? So, and this also includes for even the question that Ghada just asked. So can we assume that, okay, let's assume that they read the email. Can we say as a tribunal, for example, or the opposing counsel, that you should also have the same intentions? So let's assume that I know that previously Botanical, I'm as a respondent, I know that Botanical intended to have the 2016. Do I have the same obligation that I apply the 2016 to, or do I have my own interest and intentions and so on? And does the replacement of the contract means anything? So when they say, this is a replacement, does this mean maybe that they just want to have a new contract, a brand new contract, and khalas, that's all of it?
When you terminate the contract, you're
Yeah.
when you terminate the contract, naturally you're gonna have to do another one, or like make a new contract, go into a new contract with the other party. So like, there is the fact that do the intentions transfer, and is it the same contract?
So do you think that they transferred or not? The intentions?
Depends on the position, but in my opinion, no, they do not.
Us in answering this question, because if they wanted to change the wording, they could have done this, but they didn't. That's why we can say that their intention also transferred, notwithstanding the fact that the contract was terminated.
We have one question. It's about the applicable law to the arbitration agreement, or should we assume that only CIG applies? I would answer this straightforwardly. We should assume that the CIG applies because irrespective of the actual applicable law of which country, procedure order number 1 says that there is jurisprudence that CIG would apply to the arbitration agreement. So it's CIG anyways.
Ghada, just to be aware of the time, I think we should move on to the second one. But just one last thing, which is the intentions. I think we should all discuss the intentions, whether there was an intention between Botanical and claimant to rely or to apply the 2016. So generally, let's throw some facts that why do you think that the 2016 should apply, or let's assume just the 2016. What do we have from the facts that the 2016 should apply and not the 2025 from the discussions between Botanical and claimant?
In particular, what Noif is asking is that to which extent can you actually argue, putting respondent aside, that it was truly Botanical Gardens and claimant's intent to fix the 2016 rules?
Sorry?
I will ask one question and we'll move to the second submission for procedure. I will just say one thing to help you think for tomorrow. It appears that for the SIAC rules in particular, they have a tendency to issue practice notes. Okay? The practice notes aim is to modify, supplement, or add to the rules. Okay? If it was truly their intention to fix the 2016 rules, only the 2016 rules to apply, wouldn't they have excluded any application of any practice note? I would leave it there. Let's move to the second submission. Okay, second submission for procedure. Any volunteers? You obviously have two axes. So can the tribunal, should the tribunal? Okay? They can, it depends on which set of rules you're arguing. I believe you have your argument. But let's focus on the should in the interest of time. I believe that's the part where most of you struggle. No? If you're struggling with the can, please raise your hand. Nope. Can what? If you reach the point where you say the 2025 rules apply, they definitely can. At least for the third-party funding agreement. ATE, that's for you to make the argument. But for the should they, assuming that they have the power, should they? Should the tribunal order the disclosure? What do you have to say about that? The should part. Any volunteers? Yes.
The 2016 SIAC rules contain no provision in it that authorizes the tribunal to order disclosure of third-party funding agreements. So in that case, they cannot order the disclosure. So the absence of it matters because it wasn't mentioned. So at the time that the rules were drafted, third-party funding was not yet subject to institutional regulation. And therefore, since it's not there, it could not have been asked for.
We're still within the can part, so that's answers can the tribunal order the disclosure. And as you've mentioned, in 2016, it wasn't that prominent, but there's a reason why SIAC issued the practice note to modify, supplement the rules. But we're not discussing the can. We're discussing the should.
Just to make the difference, I think when we say can, even if it should, if we don't have the can, it means that they will not do it in the first place. So the can is for the power of the tribunal to do something, whether the rules give them the power, but the should is in case they can. Is there any need to do or to order the disclosure or no? So just to
Oh, okay.
Yeah.
So even if one was to look to the 2025 SIAC rules, the outcome in the end doesn't change because the rules require the existence of funding, they require the identity of the funder. So the disclosure would have already been made. So even if they ask for it,
So the question if the tribunal should make this ordered, it's actually discussed in practice note of 2017 when they said that the tribunal can make such an order so they can disclose the full agreement or some details of the agreement if it finds that it's necessary or expedient. So if we're taking claimant's position, which states that the tribunal should not order the disclosure, we need to say that it's not necessary. So according to the factual record, claimant contracted with ATG funding and literature to cover any adverse cost award. And it's mentioned in PO2 that he did so to remove from his sheets, from his balance sheets, every or costs associated with this dispute. And this could be the same regarding the expedient condition, which in this case is related to the demand for security for cost. So because claimant contracted with literature to cover adverse cost award, then we could state that the disclosure should not be granted in this case regarding claimant's position.
Okay, I heard a word, a technical term, necessity. You mentioned necessity. So that's what I like to refer to as a legal standard. There must be some sort of there is more than one legal standard. There are legal standards, technical terms that should be introduced to the tribunal at some point for them to be able to follow you. You might not have people that are very well versed in the case file, but they know a lot about the law. So when they hear the word necessity, they're like, this person knows what they're talking about. That's one of the requirements for disclosure. So you need to cite necessity. Necessity is just one of them. There is more additional requirements that you need to satisfy to disclose or not disclose. So you should all be very well versed in what these requirements are. So necessity and what else? Does anyone know the other technical terms? Yes? Okay, conflict of interest. And why do you think, let me answer the question with regards to Danubia's case law. Well, Danubia is the seat. So I believe the Supreme Court of Danubia's decision would be relevant since it's the seat of arbitration. That's how you get to the Danubian case.
I believe that it needs to be necessary, expedient. Also, it needs to be expedient, as mentioned, and it needs to be proportional. So
Okay.
it doesn't need, it can't be an abusive measure in the case.
Okay, so necessity, proportionality, time and cost, expedience. There is a fourth one. Try to find it by tomorrow. Okay. Okay, so
The same question for issue 1. Yeah.
I mean, doesn't it become a should when fairness require it?
yes, we're not discussing the can. We're like that's dependent on the applicable set of rules and for you to discuss whether it's part of the discretionary powers of the tribunal. At certain point in your line of argument, you will assume that the tribunal has such power and you will have to move to the should they, assuming that they have powers, why they should or shouldn't disclose the agreements. Now, the proportionality. In terms of proportionality, are we talking about equality between the parties that if both have some sort of funding, they should both disclose? Or we should only disclose what's relevant? So we don't really need the full agreements, maybe some parts of the agreements. And to whom should this disclosure happen? Are there any mechanisms that the parties could introduce in terms of disclosing?
Yep.
So the tribunal or the other party will not see those clauses that are extremely sensitive to the other party?
Okay. So yes, go ahead. She said it. Okay, we will deal with this in the upcoming. Yeah, you want to say something? Okay. So we will deal with this in the upcoming session about how to answer question. You will receive a lot of hypothetical questions, as in, would your client be willing to disclose a reducted agreement? Would you be willing? Would your client be willing to disclose some parts of the agreements or whatever? Those are very common in the VIS, and you have to know how to deal with these types of questions. You don't really have an answer in the record, but you have to deal with them.
They would be able to disclose it only for the tribunal.
In camera disclosure. Yes, that's also an option. That's also one of the mechanisms. So it's called an in camera disclosure. So only for the tribunal's eyes to see.
Ghada, I have the same question as I asked the first one, which is what are the consequences of not ordering the third-party funding or ordering the third? Is there any consequence or is it fully discretionary power? This is very important. As Ghada said, hypothetical questions, you must be ready because although this is not really in the case, but I think everyone should know the answer, whether this is a pure discretionary power to the tribunal or is it an obligation that they must do? So do you have any answer from the rule itself? Do you think that they gave the tribunal discretion or an obligation? Discretion. Why is that? Okay. The wording may. Any other?
Who's pleading on behalf of respondent procedure? We don't have respondents' councils? You can be pleading both sides, but it doesn't really matter. But if you are pleading on behalf of respondent, what's more important to your client with regards to the disclosure? Is it the third-party funding agreement or after the event insurance? Which one do you really want to be disclosed out of the two? If you only have one chance to disclose one or the other, which one would you go for?
The after the event insurance, because it's stated in PO2 that ATG funding will not be covering any adverse cost. So if it's the important point for respondent is to get the adverse cost.
Okay, so she said it's the third-party funding agreement because they want to know how the calculations will be made so that they will know as respondent, should they lose, how much are they going to pay? And you're more interested in the after the event for the adverse cost? Yes.
Because of its excessive control over the proceedings that is stated in the record in the newspaper article.
So you're more worried about the one with a bad reputation than the one with a good reputation?
Not about bad reputation, but about excessive control, about de facto assignment that can be took place through the third-party funding agreement with ITJ financing.
There is one question. Do we consider Lecture as a third party funder in the first place, or do you think it's not third party funder? Because third party funder, I think there is a definition under SIAC. Do you think that the Lecture is falls under it? Yeah, please.
I don't think it's a third-party funder, it's an insurer, because a third-party funder would be funding the proceedings from the beginnings, whereas an insurer would be covering any potential adverse cost after the end of the proceedings.
Is this the definition of SIAC? Because I think SIAC, they have a definition for who is or what is a third-party funder. I think that the requirement is the economic, what do you call it, interest. So can we consider Lecture as a third-party funder? No, this is also a question that we should know. Are they both third-party funder, or is it because you know it differs when it comes to third-party fund? Because for example, ATJ, they will pay everything and then they will just take a percentage if you win, if this succeeds. However, the Lecture is different. The mechanism of the after the event is different. So we should know the differences, because this is a question that you might be asked in Bahrain or even in Vienna. Is can we consider them as a third-party funder or no?
Do you have an answer?
It's just about the payment method for Lecture. It's going to be mostly premiums because it's an insurance, so they're going to be paying premiums. Whereas, as you mentioned, for ATG funding, it's going to be a special a portion of the amount or another way.
Okay. Any other questions with regard to the second issue before we move on to the third? Conclusion. Before we move into the merits of the case, what would you like us to discuss extensively tomorrow with regards to procedure? What are the things that you are mostly struggling with? You're fine? You're ready to plead? Let's change the schedule. Do you want to plead in the morning? You're ready?
Sorry, can we go back to issue 1? I only have a question about the qualification of the contract. Should we stress about this argument on the qualification of the contract? If it's an amendment.
Can you rephrase the question? What's the qualification of a contract?
So the contract that was made between claimant and respondent, is it an amendment or a new contract? Should we develop this argument more, or?
We cannot tell you what to develop and what to not develop.
can
That,
we talk about?
that's the wrong approach. Every argument is valuable. It depends on your audience, who's your arbitrator, and it depends on the questions you're going to receive. And you're in a responsive position, depends on opposing counsel structure.
No. Yeah.
Don't ignore any argument.
I mean, can we?
Can you
we
make the
talk
argument?
يعني, can we
you want
focus
us to
on this?
Yes,
Can we
we can.
discuss this tomorrow?
Yes, we can. We can
Okay.
discuss this tomorrow.
Thank you.
Scream. We can hear you.
Yes. So my question is, if you guys could dive more into how exactly third-party funding and AT insurance agreements actually work, and how does this process from start to end, and what are the consequences of prevailing or losing in the arbitration for the funder and the insurer?
Well, you're going to meet us halfway with regards to that. You're also going to prepare your homework.
Yes.
How do these two differ?
All right.
Okay. For the rest, you're confident in your arguments? They are bulletproof? Okay. We move to the merits? Yes. Yes.
Is it possible to change the date of arbitration only for one specific purpose, for statute of limitations, as an example?
Okay. I understood your question. We
Okay,
can discuss
thank you.
this
Thank you
tomorrow.
very much.
Okay. Aziza, I saw your question. We will keep that in mind for tomorrow. Any other thing? These are your concerns? Okay. Merits of the case? First submission? You're a merit speaker? Yes. First submission? Change your mind? Okay. Let me ask my first question. Who should start on the merits of the case? Himili.
Well, I think that's very debatable,
Mm-hmm.
right? Because on this case, claimant, it's going to be claiming that he's entitled to damage, and the burden of proof is on the person who's claiming for damage, right? And respond. Go ahead. But respondent is the one who's claiming that he's exempted. Also, the burden of proof is on respondent to prove that he's exempted.
Okay.
What do you think?
Claimant.
You think it's claimant? Respondent, claimant, claimant, respondent. That's the order you would go for.
Well, for procedure, I would say it's RC and then respondent claimant.
RCCR.
Yes.
Okay. Does anyone have any other position?
I also agree that this is very debatable, but as a respondent is one who claiming an exemption, he should firstly establish this exemption, what will be claimed as an impediment in the sense of Article 79 CSG. But from the other side, every argument of claimant is alternative, and it would be unfair if claimant would be second, because, for example, speaking for counsel for respondent would not be able to cover all arguments, and claimant will start that, of course, the opposing counsel stated that it is, for example, was unforeseeable, beyond control, but it was avoidable, and the opposing counsel could not be able to cover this defense in full. So because of this reason, I also believe that RCCR will be the best order of speech.
I agree it's debatable. Be ready to debate your case in front of the arbitral tribunal and with opposing counsel. And if you don't reach an agreement, it will be left to the tribunal to decide. Both are correct. Both have their support and arguments, I would say. Legally speaking, the party who's claiming an exemption, so 79 or 80, has to start. So in our case, respondent. But the way the question is framed is that is claimant entitled to damages? And he's the one, and it's the party that is claiming damages. Also, I do agree with the fairness part. That's the main argument you would hear in the oral hearings, that it's unfair for the same party to start twice. It's also unfair that that respondent has cumulative arguments versus claimant who has alternative arguments. I would say it's also unfair for a bit for claimant who might argue 79, but then respondent claims that it's they're exempted under clause 12 of the contract. So they will make their entire, I don't know, 9 to 10 minutes of pleading go to waste because they used a different legal basis, which is also possible. So be ready to argue your case with opposing counsel and with the arbitral tribunal.
And I think one more point, maybe we can talk more about this in the next session. But I mean, we saw different teams a few years back that they use this as their strategy. So for example, I saw the same team when they are claimant, they push to do some certain thing, either to start or to be responding. Whereas if they are respondent, they do the opposite. So it's up to the team. However, you should also be prepared, because sometimes you might enter into a room and you are just prepared to start as claimant, but you find out that your opposing counsel is suggesting something different. And then, as Ghada said, it's up to the tribunal to decide who will start. And eventually the tribunal might say, no, it's a respondent who's starting. And then now you're just all of the 3 months that you were preparing you as the starting point, you have to respond. So all options are open, and we encourage you all to do both. Like you start as claimant and then respondent.
This is a pre-moot. This is like, these are a bunch of practice rounds. Use them to try different things. Make sure to try all the different combinations. That would be a good practice for you. That's our suggestion. Okay, but everything is possible. Okay, and again, you need to use a legal basis when you are arguing to the tribunal or to opposing counsel. Why do you want to start, or why do you insist on responding? Okay, look at the moot rules. I know none of you read them, but they are there for a reason. Okay, they spend the entire summer preparing them. There is a reference of the moot rules that you could use, apart from the rationale or the burden of proof under the CIG with regards to Article 79. There is a specific rule in the moot rules that discusses this, that you could raise to the tribunal as well. Okay, now delving into issue C. What is your client's position? What are your main arguments? What is your winning argument? Oh, you know what? Let me ask another question. What is the impediment? And what obligation was breached? And I want to hear options.
Jude?
Now, the general definition of an impediment, it's like an external obstacle that renders performance impossible. The obligation that the respondent did not commit to was applying for the import permit and like getting it, because they had it under clause 5.1 that they have to get the import permit.
So for you, the obligation that was breached was not obtaining the permit, and that's an obligation for respondent under the contract.
Yes.
Does anyone else argue a different obligation that was breached? Okay, we stay with you. What's the impediment? What's the impediment?
The impediment that respondent is saying was impossible was the transfer of the vanilla orchids from Appendix 2 to Appendix 1.
Okay, so the inclusion of the vanilla orchids into Appendix 1 or the shift from Appendix 2 to Appendix 1 is the impediment. That's what all of you are arguing?
Any other impediments?
Just so we're clear, we are both coaches. We've seen all the arguments. We've read the arbitrator's brief. We know about all the options. So you shouldn't keep your arguments to yourself. The shift of policy, in particular, what shift of policy?
Just because I think we have the online, so
Yeah,
maybe it totally works.
Shift of policy is that Equatoriana, who previously had been aligned with obligation under size, has taken a more stricter approach and stopped issuing an imper permits for vague research reasons.
Okay, so basically the shift of policy with regards to granting import permits.
Yeah.
That's the only shift that happened? That's the surprising part? That's the only shift that happened? And is that the surprising part, that they were so lenient and now surprisingly they're very strict?
So also,
I like to hear about the alsos.
This was first time when CITES conference applied an immediate application. Under CITES convention, any changes in appendix should be in force 90 days after the conference was made. However, in the present case, there was immediate application. So when the conference decided to transfer orchids from Appendix 2 to Appendix 1, then the changes came into force.
Okay, now we have around 3 options. So the inclusion of the vanilla orchids into Appendix 1, the inclusion of the vanilla orchids into Appendix 1 with immediate effect, and the shift in granting policy in granting permits within the Equatorianian government. These are the only 3 potential impediments, or there is another option that you could argue?
Emily?
So there was a shift to Appendix 1, but the main impediment is that in the appendix, they wanted to stop it from being sold commercially, not for research purposes.
Banning the trade of vanilla orchids altogether. So that's a 4th option.
And the 5th option, there was an NGO, there was a campaign, a very successful campaign that was shockingly very successful. That stopped. This was one of the impediments too, politically.
Okay.
I think the answer that you're looking for is for the 3 greenhouses.
Okay, 3 greenhouses.
Yes, that it was responded responsibility.
Okay, so basically you have 6 options in total for now. None of them is wrong. To be completely fair, none of them is wrong. You can argue any one of them. It depends on how you argue them and how convincing you are. So we potentially have 6 impediments that they didn't have where to put the greenhouses, where to put the orchids. The inclusion of the vanilla orchids into Appendix 1, the immediate effect of such a decision, the shift in granting permits, the policy of the Equatorianian authorities, their intention to ban the trade of vanilla orchids, and the NGO, the public pressure from NGOs. Which one affects, because who gave us the impediment to begin with? Someone presented the impediment, and you said it's the not the obligation that was breached was particularly
5.1, clause 5.1.
Yes, so getting the permit.
Yes.
Which of these impediments you mentioned actually affect getting the permit? All the options.
The recommendation to transfer the vanilla orchids.
Okay, with immediate effect, without immediate effect, the shift of the authorities,
With the immediate effect.
with immediate effect. Okay, what is there any other obligation that you could argue that was actually breached? The accept and delivery. Accept and delivery of the vanilla orchids?
No, I meant payment for the vanilla orchids.
Payment. So the payment obligation. Okay? So you're saying payment obligation, you said granting the permit. What were you going to say? Force majeure clause? We haven't gotten there yet.
Excuse me, the people in the chat actually want to get in on this conversation.
Student know that accept. Can you accept them in the meeting?
No, not me.
You cannot? Can you check with someone from BCDR? We're working on it.
There is also a notice for the impediment that was breached.
Notice. Okay, notice under which provision?
79 CISG.
79 for CISG or 12.2? 12.2 of the contract.
Both.
Both? Now my question. So we have Article 79 and we have clause 12 of the contract. Which one supersedes the other? What are your options? You see, when we're asking you questions, there is no correct answer. All the answers go both ways. Okay? So give us the options. We want to hear options. Yes, he mentioned Article 79. You mentioned Clause 12 of the contract. I was like, which one supersedes the other?
They're complementary to each other.
Complementary, according to what? Big words, no legal basis.
Basically, from my understanding, is that
Your understanding
did a lot of research.
Emily, since
Yeah.
when is your understanding relevant?
The Article 79 of the CSG, it's a broad article that does not include the events, exactly what are the events that it's a force majeure or so on, like, you know. So the clause 12.1 of the contract, it does give us those definitions of what are the events that would be considered a force majeure.
Well, if I read Clause 12, I would say that it also says including but not limited to. So it's not really an explanation of what an impediment is. It gives its own definition. So to which extent can we still consider that one explains the other?
Or for the durations, for example, we have 5 days and we have Article 79.4, it doesn't say any specific day. So does the contract prevail over the CISG or the other way around?
I'm not saying complementary is wrong. I'm saying what is your legal basis for that? It's correct, but without a legal basis, I will, as an arbitrator, consider it a wrong answer, that you don't know what you're talking about. One supersedes the other is correct, but you need to mention which one supersedes the other and why. If you can consider them together in tandem, what does it mean, according to which legal basis and how?
There also can be in positions that Article 12 does not mean anything because it is attempt to derogate from CISG. However, a derogation from the convention should be explicit, and we cannot find it in the text of Article 12.
Okay, I heard the word derogation and it should be explicit. Where do you get this idea from?
CISG Advisory Council opinion number 6.
Advisory council, okay. This is a scholarly opinion. It's an advisory council, yes. Is the advisory council opinion binding in any way?
No,
No.
it's not binding.
What was that advisory council opinion about? Which provision of the CISG?
About Article 6 of the CISG.
Article?
Article 6 of the
So
CISG.
we do have a legal provision. It's Article 6 of the CISG. advisory council opinion explains how we should apply Article 6 in a uniform manner, that a derogation should be expressed, not implied. But that's also, to me, it's debatable, okay? Because what constitutes an express derogation? Now, my question to you, now we do have a mechanism of Article 6 that you can derogate from a provision of the CISG. In particular, Article 79, that's the clause, that's the article in question. Is Clause 12 different in any way from Article 79? Because even when we're talking about derogation under Article 6, we can derogate partially or fully. And when we derogate partially, we can, for example, lower a threshold, heighten a certain threshold. That's also possible. So in which situation are we? And Himmel, if you're still in the position that they apply together in tandem, you need to find an authority or a case that states so.
I think we have like few minutes left, and we need to go to issue 4 because I think the next session is more important, and we only have 1 hour. So if we may go direct to issue 4 and just say what are the weakest arguments that you have that you want us to discuss for tomorrow, so we can just wrap this up and then just move on to the next session.
I would like to say that variable quantity clause and the exact number of orchids seems to be hard argument because there seems to be a lack of authorities, a lack of case law.
Who gets to decide the exact number of orchids, right?
Yeah.
Okay. And what else? That's your main point of contention?
Yes.
Yes, okay. Any other thing? Can you give us a context about the down payment thing?
So basically for the cover sale that was concluded in 15 February, it was actually paid 50% of the cover sale and in the contract that was concluded between Herbal Cosmetics and claimants in 2021. So yeah, my question is, how is the down payments would be sufficient to consider a cover sale pursuant to Article 75 CISG?
Okay, so we have an issue with regards to how was that cover sale paid? You have something to add? No? Anyone else who has an issue with their second submission on the merits? Are you all arguing 75 only? Do you have some sort of alternative arguments to 75? That's your only option? Of course not. What is your other option? 74. So you go back to the general rule. My question is, how do these two provisions differ? Is there any additional requirement that you need to fulfill? Apart from the existence of a cover sale, apart from that, which is more difficult to prove?